But may have lordship leave to mention well, two matters extremely urgent. Ready for hearing, one of 2019, one of 2020. Both are extremely urgent. Otherwise, they won't have trouble.
Oh, have you given notice
Yes,
to other
yes,
side?
yes. I have next the notices.
Yes.
I'm deep.
Okay. All are mentioning, but at the time of call, either the petitioner or the respondents remain absent. Yes, yes. Okay. I shall see.
My lord, may I have you kindly mention 3 hearing matters and 1 substitution application, my lord?
Okay. Under the heading application, দিয়ে দেবে.
I will not leave to
Oh, 51. Oh. And hence at the time of call, anyone should remain present. In this way, it is not the system. It cannot be, if it is not signed, আপনি দেখবেন তো 51টা কালকে ওটা সাইন হয়ে গেছে কিনা Who is the other side? I don't know whether he was present at the time of call or not. In this way, when the matter will be called, then anyone, any representative should remain present. Okay, if it is not signed, then it would be. But if it is signed, then nothing can be done. Oh, okay.
and you have to be
Yesterday, yeah.
No, my lord, department said to separate petition to separate review has to file. Yesterday one.
Oh. Yes.
But I am for the petitioner. No, one application for injunction, another for appropriate order. Those are basically infectious if the original writ application will be heard by your lordship. So matter is, all the matter has heard analogously and dispose of the same. On the last occasion, your lordship directed to the state to file an affidavit in opposition. 2 occasions, that till today no.
You are for respondent number? State.
My learned friend has already been filed an affidavit in opposition. I have also given reply, but the state has yet not been.
When the order was passed to file on last occasion,
19th February 2020.
time for filing a extension was given to file affidavit in opposition. It is not that it will get indefinite period. Yes, you place the case, no, yeah. Now, hence, it would be ordered that all the allegations ever made in the petition are admitted by the state. An order shall be passed accordingly. When initially direction was given to file affidavit in opposition. Long back. Thereafter, again, only state has done one thing. Sometimes they appear and press for going on praying for extension of time to file affidavit in opposition. Yes, what's the matter about?
But the land acquisition without make any compensation, without the land has been acquired by the state and ultimately the Jalpaiguri Development Authority. দুটো কপি করেছিস মাত্র?
In the month of April 2024,
হ্যাঁ, yes.
extension was given. Thereafter, in the month of August, again extension was given. In the month of February, again extension was given. It is the conduct of the state. Okay, with cost. No, that would be deducted from the fund of the district magistrate and district collector. You are requiring body. You place the fund before the authority. Huh? So, why you will acquire the land without making payment of compensation to the landowner? When the land was acquired?
2004,
2004, 20 years.
20 years.
Every time, lady, 3-time extension this court has granted to you. 2 is no. It is unfortunate to make this comment that the state has taken
Directly for the petition in this matter, your lordship has passed an order on 20th February 2025, directing the respondent bank to file an affidavit of calculation parental because they have failed to file on last three occasions. Yes, we have brought today.
Have you sharp copy?
No. We have to consider this.
And they are also
You filed, you complied.
Nothing has to be filed, but you will have to kindly come and see the order. Nothing has to be filed.
He
Reply to the court.
opposition আছে page 19. Opposition page 19.
The petitioner was also instructed to produce photocopies of the certificate. The original copy there. But they have the
So I have not find out the particular portion. Order dated? Okay, yes. Second paragraph, yes. The petitioner is directed to prepare and produce a chart detailing the amount received against each fixed deposit certificate. Petitioner also instructed to produce photocopy of the fixed deposit certificate and it available the original copies thereof.
The chart is already there in the records. The chart in 2008 is annexed to the petition from
You file another chart.
And it takes their affidavit reply. I'll pick one page from their affidavit reply.
Okay, the court will apply its mind, judicial mind, yes.
But the fixed deposit certificates are not in our custody.
Acha, the affidavit filed on behalf of the respondent number 4 and 5 in terms of the order dated 24th April, 22nd April 2024 and 20th February 2024 are taken on record. Stop. Copies of those two affidavits have been handed over to the learned advocate representing the petitioner in court today. The petitioner is directed to take to obtain necessary instruction Stop. And petitioner is directed to comply with the order dated 20th. Item number 3, 2010-এ এটা কি তাহলে একজন হিয়ারিং এর তলায় দিয়ে দিই। Okay, Thursday. Huh? I couldn't understand who is appearing. So Passover asked him to come. Passover, yeah. Passover asked him to come. Yeah.
Arrive for the petitioner. This is in respect of modern market.
Oh, Mr. Toll is appearing.
May I conclude? May I make my submissions?
No, in his absence. Yes.
Difficulty.
Let him come. Either I am passing it over or not today.
Not
Choose you. Not today. Yes, not today. You give an intimation. Ask your junior to give an intimation to Mr. Udhol.
Huh? Oh, then Thursday, my lord.
Thursday, okay.
But
20th. Eh?
But
20th, ask your junior to give an intimation to Mr. Dhol that the matter will be taken up on Thursday. Hmm.
my lord, whenever I come, this matter is not hard for some reason or other. This is
Okay,
fact.
sometimes time has not come.
Time has not come.
Time has not come. Everything there is a particular time.
Star
Before
is
that, it would not
Star,
will happen.
star is not favored.
Yes, yes,
Deep down.
yes. 7.
Seven, I'm the petition. One thing, some document I already obtained, my lord.
You have to obtain.
Yes, but I have already got. Petitioner wife already got yes. Same putting I can find.
Okay. At the petitioner place for leave to file. Yes. Huh? Not today. Okay.
I am for the petition.
Hmm. Yes. Which is the other side. Every year service of the writ petition. From long back.
After filing matter,
It was filed in 2018. Thereafter, you have not made any effort to get the matter listed and to have disposed of. You are not so serious to get the order as you paid for. Okay, what is your pair?
They have not getting his
Pay area salary
area.
of the petitioner which has been assessed by the school authority amounting to such and such.
Yes.
Why you will get area?
That I do not know. And your lordship can see annexure P7, page 28. Department directed your petitioner to file a fresh proposal. Page 27.
Undersigned directed to request him to refund such and such amount from Narayan Sankar Kar.
Yes.
You are Dilip Das.
Yes, and Dilip Das, a fresh proposal to be submitted.
For other cases, Dilip Das assistant.
Retired assistant teacher directed to file a fresh proposal. On next page,
but I have filed fresh proposal. That is on 28th of September 2017.
According to phase proposal, you are entitled to an area of a sum of rupees 1,68,000 and odd. So we are seeking direction to make payment of the same. You are an organizing teacher. Thereafter, the school was recognized. Then dispute cropped up from which date your appointment will be approved. Initially, your appointment was approved since 1st January 1988. Thereafter, you approach this honorable court, file a writ petition.
1185.
In compliance with the said writ petition, your appointment was approved with effect from 1st January 1985. And you are untrained.
Yes.
So your increment was stopped for certain period of time, for 4 years, 90 to 94. Yes, thereafter your increment was started since 1195. And for this reason, some amount was, however, ultimately district by a memo dated 2/7/2012 sent to Director of School Education stated that an amount of 1,68,000 and odds are area is payable to you. It is your case.
That has not been.
So if direction is given, to whom direction would be given? Respondent number 3.
Yes.
The Next.
Why not? Your learned advocate Sophia Chattopadhyay ill. Now I am praying for one adjournment. I am for the I am on behalf of the petition.
So not this week will serve purpose.
No purpose, sir. He is ill, sir.
Oh.
Now
I
I am praying for one adjournment.
Okay. Affidavit opposition filed on behalf of the respondents is taken on record. ঠিক আছে। File affidavit in reply in the meantime and give a copy. Next.
11, I am for the petition. This matter was heard on 26th of August 2019. And affidavit direction was
Given, but no such affidavit.
no such affidavit has yet been.
Have you taken information who is now appearing for the state? Supratim Dhar appeared in 2019 and for municipality case of Chandra Das.
Your lordship, I give notice, then came back.
2 weeks.
What?
1 week. Which municipality?
Taradeshwar.
So 2 weeks you give, eh? Acha, yeah.
Well, my lord, I appear for
Yes.
the petitioner, my lord. My lord, here, my lord, what happened, my lord? The petitioner number 1 died. Now, my lord, we have taken out an application, my lord, for substitution. Now, my lord, during the pendency of the substitution application, my lord, the applicant, the wife of the petitioner number 1 was one of the applicant along with the sons and daughters. Now, my lord, the wife has also expired. Now, my lord, if your lordship kindly takes up the, my lord, the last order is of Honorable Justice Hiranmaya Bhattacharya. The order previous to that, my lord, is of Honorable Justice Sugata Bhattacharya. My lord, if your lordship, my lord, kindly takes up that, lordship directed us to file an application. My lord, the application is being affirmed today, my lord. If your lordship, my lord, kindly keeps it in the next week, I shall, my lord, file that application and serve it, my lord, to my lord.
So not this week.
Lordship.
Not this week. Okay, it will return.
Or I am for the petition.
Yes.
After exchange of affidavits, my lord, the matter has appeared this for the first time.
Huh?
The matter has appeared, my lord, for the first time before a lordship after exchange of affidavits. May I file the affidavit in reply?
Now at present there are 3 hearing benches. Okay. Not at any point of time in any court, the matter may appear. If you are filing affidavit reply,
Yes.
who is for your other side? Pinaki Dhol.
I have already informed.
Okay, I am making note this week. You give notice to Mr. Dhol.
No, it will be taken up next Thursday.
Thursday.
Next Thursday.
Okay, yes. 14. Okay, 21st March.
Lord, 15 can it be taken about 20th, my lord? Other matter has been fixed, your lordship, on 20th.
20th, who is the other side?
I have to sub the
You give
in the
information. 20th,
Yes.
okay.
Lordship, in item number 16 is Mr. Devajisha is appearing on behalf of petitioner. Lordship, kindly fix this matter in kindly fix this matter in another date, Lordship.
So tomorrow it is fixed.
Okay.
Ask him
Grateful,
come
Lordship.
tomorrow. Yes, not today. 17. Okay, নিচে নামিয়ে দিন একজন হিয়ারিং পরে এটাকে ইয়ে করা হবে Yes.
Last 8. ওটা লাগবে খাই পাবি না তো
Affidavits are complete.
On which side of the reading? For 1 week.
I just can, because the time was fixed by division bench.
My lord.
Now, whether a single bench should extend that time. So I am just ignoring and I am just giving you an adjournment. You file, you complete in the meantime. Okay. I should not extend the time fixed by a division bench of this court. That would be tantamount to modification of that order. So I am just ignoring as prayed for on the joint pair of the learned action is given এটা বন্ধ করে দেওয়া হয়েছে এটা বন্ধ করে you will file 2 weeks Hmm. Hmm. Yes. You proceed. You proceed.
It will not take more than 10 minutes.
It is your affidavit in opposition. তাহলে affidavit exchange by the parties are taken on record. ঠিক আছে হ্যাঁ আচ্ছা Okay, 2 p.m. Come on. Yes, yes. At 2 p.m. means. Okay. Now, adjourn here, Papa.
Just one thing I am interrupting. We are learning every day from the code. I am seeing the document indicating that I cannot extend the time beyond the time fixed by a division bench, which needs to modification of the order of the division bench. Normally, we
Yes, it is adjourn hearing. Do it.
Yes, my lord.
Huh?
There is a direction. There is a direction to file a report by the council, my lord. Till date, no report has been filed, my lord. Yesterday they took time.
What's the matter about? Why report was called for?
My lord, it's a compassionate appointment, my lord.
Compassionate appointment.
Yes.
Whether it is for the first time or second round,
No, it was rejected, my lord. My prayer was rejected.
Prayer was rejected for what is the count?
Page 29 is the rejection order, my lord. They are citing a notification and rejected my claim. Nothing has been spelled out in this notification, my lord.
So they are saying that now there is no scheme for
No, my
giving
lord.
compassionate appointment to the children or dependents of a teacher who has prematurely retired from
Yes.
service.
My lord, they have relied the notification, my lord, 30th 7 2004. but it was, that is the not the date of consideration, my lord. At the, but I was physically incapacitated. Page, my lord, page 22. 19th December 2011, 2003, I was declared as physically unfit, and they have considered my prayer, my lord, of in 2004 circular.
No, you have been declared
Page 22, my lord.
Permanently incapacitated on
19/11/2003, page 22.
Oh, in the month of November 2023.
Yes, but they have rejected my.
Now, when you made application?
My lord, I made an application, my lord, prayer for appointment
On 15th
15th
April 2024.
And they have rejected my claim, my lord,
On the
relying a
ground that-
notification 30th July 2004. After making the application, my lord, they have rejected. And in the scheme, there is page 30, my lord, the notification which was relied on was memo number 71820 AC primary, my lord, same was annexed in the writ petition, my lord, page 30.
Where is that memo?
My lord, page 30, in terms of this notification, they have have you
not brought that notification?
Today the
Oh,
notification.
this is the notification
30th 7 2004.
So it is also referring another notification.
Yes, another notification. And subsequently, my lord, in the rule, my lord, the scheme is there, my lord. I have 57 SC circular I have brought today, my lord.
So you give a notice to Mr. Samanto. Have you got that?
57 SC means circular, my lord.
That's
this notification. And this notification supports my claim, my lord.
My lord, I am for the state led by Mr. Jayanto Samanto, my lord.
And there is a direction to file a report.
So appeal.
My lord, on the last occasion, my lord, on the yesterday also, respond number 4 and 5, there is a direction to file a report, my lord. They took a time, but I am for the state, my lord. Respond number 4 and 5 for the council, my lord.
Who is appearing for 4 and 5?
Mr. Pinaki Bhattacharya is appearing for the Mr. Pinaki Bhattacharya and Bhaskar Boshat Boishu. Yesterday they appeared.
Yesterday they appeared and took time, my lord.
Oh. So I am fixing it 27th March.
Or my lord, keep it on 20th, my lord, so that I can serve a notice.
20th means 48 hours.
They appeared yesterday, my lord.
27th March. March of last, my lord.
Some other matters have been fixed on 20th, so then.
My lord, I inform Mr. Bhaskar Boshat Boishu, my lord.
To them. And in the meantime, if you want to bring on record the notification, you can file supplementary affidavit.
My lord, 27th March.
27th March.
March of last, my lord. March of last.
Represent the petitioner, respondent number 4 and 5, though Mr. Imtiazuddin, learned advocate for the petitioner, and Mr. Chaudhary Mojumdar, learned advocate for the state, are present. Stop. Mr. Imtiazuddin plays for leave to bring certain circular.
It is a government notification.
By way of
it is a government notification.
Or the certain circular and the notification by way of supplementary affidavit. Let's have supplementary affidavit be filed within a week.
Not record at all, my lord. First, your lordship see the notification. Thereafter, if necessary, my lord, I can file.
Filing supplementary affidavit. Place for leave ta kya hota kere chaiche na paise. List the matter for further consideration on 27th March 2025. The petitioner is directed to intimate this order to the learned advocate To Mr. Bhattacharya
Yes,
appear?
my lord. Pinaki Bhattacharya.
To Mr. Pinaki Bhattacharya, a learned advocate who has been entrusted. I have been informed that Mr. Bhattacharya has been entrusted with the job of defending the respondent number 4 and 5. Stop. In view thereof, the petitioner is directed to serve a notice upon Mr. Bhattacharya intimating that the matter shall be taken up for further consideration on 27th March 2025.
Much obliged, my lord. Much obliged.
Not my application.
Yes.
Mr. Chair. Mr. Chair. I answer.
There are 6 applications.
Yes, yes.
Why
Can
6
Can 3 is more important, my lord. Can 3 is praying for a modification of an earlier interim order passed by Honorable Justice Dipankar Datta, as your lordship then was. I'll tell you.
Can 3 is the modification.
Yes, that is very
Now,
important.
can
I
5?
need to first, my lord, I need to press can 3 first, my lord.
Can 5?
My lord, can 5
Huh? Can 5 for stay.
stay. Interim order কি vacate হয়ে গেছিল?
Can 5
Every day after either on behalf of the petitioner or respondent.
In fact, my lord, this is a very unfortunate matter. My lord, pendency of an interim order. Why this modification? I just in a nutshell, if I may, lordship, they are praying for time. I won't press for that. I don't oppose that also. But what has happened, my lord, this matter, I understand my lord has the occasion to hear this matter. My lord is sitting in singly, as and when your lordship was sitting singly. My lord, my clients, the petitioners before your lordships, they are the licensee in respect
That
of the
Metro
shop.
Railway.
Metro Railway.
Oh.
Tolerance. My lord,
So all the applications will be disposed of first. Thereafter, the
main writ
petition will be
main
taken
writ
up.
petition.
You do one thing. You prepare a chart.
Lordship.
For can 9 for this purpose has been filed.
Lordship.
Can 8 for this purpose has been
Lordship.
filed. Okay.
And my lord, I would respectfully submit and request your lordships, my lord, to take up can 3 first, because if can 3 is ultimately, my lord, modified.
I first you give me that understand the what is the application for.
Lordship.
Thereafter, kindly allow the court to decide which application shall be taken up first.
Because if can 3 ultimately is allowed, subsequent.
Now, what is can 9? Can 9?
That's an. I'm told, my lord, during at different point of time they continue to issue notices. So and every against all these notices, separate applications were filed for stay of those notices.
Okay, I am making it not today, but today whether this day will be sufficient or you will take much more time. So not this week.
I think
I want a chart that can 3 was filed for purpose of such and such. Can 5 was such and such.
Kindly take it up on Monday.
Okay, on 24th. And you keep this application ready. If it is not possible from take out from the record, from your ear, I shall dispose of. Taking the copy from you, I shall dispose of. আর করুন তো আপনিও in the meantime application গুলো সাজিয়ে রাখবেন বুঝতে পেরেছেন?
Monday.
Monday, ask her to come on that date. Yes.
May the matter retain its position in the list.
It will remain. It will adjourn hearing. If you don't appear, then it will be dismissed. Adjourn hearing means under that heading. Yes. আপনি ম্যাটার জানেন কেন? 22. Yes, none appears, nor has any accommodation been sought for. কেটে দিন। দেখছেন any action taken. Yes.
In the,
Yes.
in the last occasion, your lordship directed to serve the copy to learned advocate appear on behalf of the DPSC. Lordship, order number 20th February 2025, your lordship learned advocate on behalf of the DPSC appear, how I appear, your lordship directed to serve the copy to learned advocate of the DPSC. I have served the copy. My learned correctly saying the DPSC is the answering respondent.
Okay, you place your case, what can be done? You joined as assistant teacher of primary school council,
Thereafter-
assistant teacher of a primary school.
Thereafter, I have appeared in the secondary recruitment of the secondary examination. I have got chance, and after receiving the chance, I made prayer for release from the primary school council. Then the primary school council wrote a letter which is at page 15, P2, second paragraph. Your lordship got it?
It is the office memorandum.
Yes. Office memorandum, where it is stated, lordship got it, page 15, P2. And also, this is the evitability service where I wrote a letter to the DPSC. If you fail to produce the particular memo on the basis of which you are directed to refund the 65 days salary, if you fail to do that, I submit before the honorable court to pass appropriate order that there is no particular memo. And
now, where is that memo? Where is that your first appointment letter?
That appointment letter is not the matter of disputes, my lord. That has been.
Oh, where is that condition that you are to give 3 months notice before
Yes,
leaving?
I am asking for that. That my lord will be correctly saying.
It is your appointment letter. It was issued
Yes.
based on which you joined your first posting as assistant teacher of primary school.
I am challenging page 15 P2, my lord. Office memorandum. It is the where I asked to refund.
It is the problem.
My lord.
You have to produce the document first. First, where is that rule?
So
and first appointment letter.
So I am
that this clause was given. Or appointment is nothing but a contract like offer and acceptance. So they offered you that I can offer this service to you on certain condition. If you accept, then that both terms and condition will be binding upon both of them.
But
now it was the condition that if you want to leave the job, then you have to give 3 months notice. You gave us that notice in advance of 25 days. 25 days in advance.
So they
so there is a breach of that clause. The court want to know that where is that clause and where is what is the rule.
Is there any stigma on that content?
Yes. keeping the court dark about the condition of service, about the rule relating to this or governing this field, how you can expect an order?
But
from
and
a
I am repeatedly asking the question to the DPSC by serving several letters.
Okay, the matter is now in the court, is in sessions of the matter.
Yes.
Now you have failed to dispose of to resolve the issue. Now it is the court. Now to resolve this issue, court required these documents. Your appointment letter and the last page where the condition is generally given that you have to give a 3 months notice before leaving your job. Where is that condition?
If there is
First,
no
that
condition,
yes, this condition is binding upon both. Court want to be assured. Thereafter, what is the particular rule? Because it is not mere a contact in between two private persons. As and when this contact offer is accepted, then there is a rule. The service rule will come into play. It is the difference in between a government job and a private contact. Then you will be governed by a service rules.
in the last occasion, your lordship, as no one appear.
You in this way, don't place your case. In this, liberty is given to file supplementary affidavit. Okay, burden is always you. Though admittedly you deposited.
Yes.
So prima facie it is appearing that you have accepted.
No,
their claim.
That otherwise they cannot. I shall not able to join in the higher secondary post. So at that time, without raising any objection, I deposited the amount. Thereafter,
court did not ask you to explain the what reason prompted you to deposit the amount. Okay, you wanted to join immediately, and hence you deposited. Okay. But it is an acceptance of their contention also. Now, whether after accepting this, afterwards you can challenge or not. It would be whether waiver your right to challenge or not.
If I shall not deposit, I shall not be released. So, on that,
if you want judicial determination on this way, not in this way. Problem is that in a jurisdiction it is problem. You have to come with legal principles. If you want judicial determination of the question, that whether it would be tantamount to waiver or not, waiver your right to challenge afterwards or not.
Yes.
Suppose I say that I shall get ₹5 from you. You somehow, to avoid the dispute, you paid me ₹5. Yes. Can you subsequently raise the point that no, you will not get the same?
After submitting the proper representation before the concerned authority, and in that representation it is clearly stated.
I am giving you leave to bring these documents by way of supplementary affidavit. Appointment letter and the rule. ঠিক আছে? আচ্ছা during hearing, learned advocate 25. DD মানে dismiss 24. Dismiss 24. হ্যাঁ। On earlier occasion also, same ground you took time. It was adjourned on several occasions.
Yes.
Dayasankar Mishra.
Then my lord,
7th October, in the month of September, in the month of April, on several occasions. Will you do it tomorrow?
tomorrow, my lord.
Tomorrow, if you don't appear, it would be hard expertise. Eh?
25 my lord. Done. এক minute.
Yes, yes.
26th of
Not
May.
today, just not today. Hey, on whose behalf you are here?
Respondent Mr. Hon'ble Mishra is appearing.
Now.
No.
My lord, my matter is 25. My lord, I am coming from old building. 25.
Okay, that dismiss করতে হবে না।
No, my lord, 25.
Mohan, you are for the petitioner.
My lord, I am for the petitioner. Mr.
You
Bhaskar
know who is for your other side.
Purulia. I was informed, my lord,
For
over telephone.
state?
Regarding stage, my lord, hearing. Let them affidavit. Affidavit has been affirmed by the council. I shall have to give reply if the affidavit has been served upon me. My lord, I am praying, my lord, only other grounds is this. Well, my wife is to be admitted in the hospital today for operation. So I am praying only, my lord, not this week.
Not this week or 2 weeks?
No, not this week, my lord.
Okay, not this week.
Not this week, my lord.
25 not this week.
My
Yes. 26 not today. Yes.
This matter, my lord, I am appealing for the respondent, my lord, in earlier occasion directed me to file opposition, my lord, because, my lord, this is a 2013 matter, my lord, and some documents are lost from the department, my lord.
No, it was.
My lord, kindly give me some time.
Document was document.
Give me some time, my lord.
Document should be kept pretty. So since the High Court is in season of this matter.
My lord, kindly give me some time. File my opposition, whatever document you give me, my lord, I can.
At any point of time, the court having power to issue a writ of certiorari can call for the record. So you keep your record ready.
My lord, kindly give me some time, my lord. I file. My lord, but in my affidavit, I disclose all the things. No, my lord. They are not the same footing, my lord. And that's why. No, there is no distinction. They are separate category, my lord. Kindly give me much time. 2 or 3 weeks time, I'll file my affidavit. And
You are given 3 weeks times in the month of April 2024.
I
Huh?
Yes, my lord. That has been, I file, my lord. Preemptory, my lord. Preemptory. Within 3 weeks, my lord. Preemptory, my lord. My lord, kindly, it is the preemptory direction, my lord. I file, my lord. 3 weeks, my lord. Preemptory give, my lord.
Because, my lord, as soon as they retire, now my lord, I will have to make a further claim that give me the damages for that period and lordship knows that is upon the discretion of the court. Lordship would call for the records, my lord.
My lord, I disclose all the things, my lord, in my affidavit, my lord. Kindly give me 3 weeks preemptory, my lord. I file.
So 1 week?
No, my lord, 3 weeks.
No, 1 week.
No,
What
no,
are
my
we?
lord, 1 week.
No, so since you are an authority,
My lord, kindly,
you will
kindly,
go
my
on
lord,
taking
3 weeks,
time.
my lord, within 3
It
weeks,
is
my
a
lord.
matter of 2030.
Kindly preemptive direction, my lord, given, my lord.
There was an order passed by a single bench of this order. They did not comply with the order, discontinued our employment. We filed a complaint. मतलब the honorable single judge, मतलब my justice order है ना तो ये exception it was, मतलब issued a rule of contempt. Telling them that rule of contempt is very tough to
Not in this matter, my lord. Not in this matter, my lord.
But that rule of contempt, the honorable division bench dismissed their happy. They went up to the honorable Supreme Court. Honorable Supreme Court said give them employment well.
That matter is not connected with this matter, my lord. That is separate, my lord. That is separate
Oh.
action.
In this way, if you suppress this voice, in this way we will not do.
But that is, my lord, cause of action
Yeah.
different, my lord, in this case, my lord.
I am trying to find out the order to consider your conduct. In the month of 16, 2000, yeah,
Given, my lord.
in 2016, direction for affidavit was given for last 9 years.
My lord, kindly give me.
So you have nothing, you have,
My lord, kindly give me.
you are not in a position to control.
This is last chance, my lord. Last chance given, my lord. Last chance given, my lord. Last chance.
In this way, you took time for 9
No, my
years.
lord, I will not take any
For
time.
last 9 years.
My lord, after 3 weeks, I will
It
not
is
take any time.
DBC. Yes, DBC.
My lord, I will not take any time, my lord.
We are
After
not
3 weeks, my
satisfied
lord,
with the
if I not
conduct.
find my within that 3 weeks, my lord, there lots of get the matter expert without affidavit, my lord.
Yes, adverse inference shall be taken.
Yes.
That would be treated as an admission. Unless
Yes,
the
yes,
court
that
takes
means
court takes this
without
stand, the authority will not be changed. They are habituated in going on taking time over the years.
This is in a separate case, my lord. This order is not applicable this case. Well, I will explain, my lord, in my affidavit.
Total vacancy.
চক্রবর্তী?
Yes, yes.
Next.
28 million matter heard by your lordship and not earlier than 23rd April.
Two application. Why? There are two application, can 1 and can 2.
Both applications is effective, my lord. Now rule has been changed. State has to submit their submission, my lord.
Rule has been changed. Minor minerals matter. 2016 rule has come.
Has come, but there is a provision, if there is any court case or any clear intervention there, that can be considered as.
In terms of the previous rule.
Yes.
Where is that rule? Any judgment is there?
No.
Judgment or rule? Who is your other side?
Mr. Lolit Mahato, my lord, as per your lordship decision, we have served a copy.
Mr. Mahato. Pinaki Sadhan Rai Chaudhary for the state. Respondent number 7, Ashok Kumar Chakraborty in 2015. Lastly, the matter appeared in 2022 when Lal Ratan Mondal and Dilip Kumar Sadhu appeared for the private respondent. For the state, I am giving a direction, you serve a notice in the office of the learned government pleader. I shall stop. Whether they appeared on the previous occasion. Okay, any interim order is there? No. Okay, dismiss for default. Appears '30, 19. Okay, এগুলো নতুন ম্যাটার তো এগুলো নট টুডে করুন নাকি নতুন ম্যাটার তার আবার চান্স দিই ওকে, এটা adjourn hearing এর আন্ডারই রাখবেন।
I'm
Yes.
for the petitioner. See, there was a direction for filing opposition. I have not received any opposition. No opposition has been filed.
Affirm means it is filed, it is not that. Whether it with record. Okay. Affidavit of service, petition. No, it is not with the record. It is affidavit of service and thereafter it is writ petition. No. So reaffirm this and file it. Huh? I am not taking cognizance of this fact. I am just adjourning the matter. 2 weeks time is given. Now only the person concerned will come and affirm it. It has not been how court can take cognizance. It was affirmed as per your oral assertion. Oral submission, that is affirmed. The copy has not been served. The copy has not been brought on record. So how court can take cognizance that it was affirmed without any proof? So I just one thing, I can simply adjourn the matter, or I can extend the time.
Yes, Lord, will kindly record.
Affidavit in opposition to be filed by November 18. Specific date was given. Okay, I mean, Mr. Ghosh, learned advocate, repenting the
My Lord, I am on behalf of the petitioner, Mr. Shahjahan Ali, my Lord, I am requested to say that 33, 35, 36, 37 may be taken up at
2 p.m.
these 4 matters.
Okay, 2 p.m.
33, 35, 36, 39.
34. Now 34. Abni forward. 34.
My Lord, although I am for the respondent, but integrity of the petition we have.
Which matter?
34.
Let the matter call down. 34, yes. Din 34 din. Yes.
My Lord, not on the point of mentality of the fact and the repetition and the mentality of the repetition. My Lord, I am appearing on behalf of the board, but there is no board. And the board, there is no board. This is a case
Presently, whether there is a board or not,
my Lord, the claim of the petitioner is regarding gratuity, excess gratuity, admissible gratuity has already been. The question is the whatever portion is claiming, that is the policy matter of the grant. And the other than the board, the policy matter cannot be taken by the special officer or anybody.
The matter relates to payment of gratuity along with interest.
Gratuity that is related to excess, admissible gratuity is already given. According to
Now you raise the maintainability of the issue of maintainability of the writ petition on the ground that on appeal lies and the matter is required to be referred to the registered cooperative society.
This is a cooperative society, adoption, my lord, this is the relation of the gratuity that controlling authority is the proper authority. Controlling authority regarding the excess payment of gratuity, any dispute arises according to section 7 of the Gratuity Act, my lord, that is referable to the controlling authority. And this is one fact. There are several judgments of the court.
Yes, yes.
My lord, there are several judgments of
No,
the court.
he is for the respondent. Whether you lordship hear the respondent.
No,
or the
he
high
is.
court.
I'm raising the point of
Please, don't shout. Don't shout. I am the petitioner. Let him take the. Don't shout here.
Okay, let me enter into the fact and let me hear the petitioner. If it becomes that the writ petition would not be maintainable on this ground, appropriate order shall be passed. Let him hear first.
But I
Okay.
have not acted because there is no board. But I have just, this is my subject.
Let him go anywhere.
From the court.
Let him go to the Ganges.
And this is the policy matter. Apart from all these things.
I'll make submission.
And thereafter, my lord, you are possible.
I will make submission. Shouting will not do. This is very difficult. He is not a regular.
Yes,
petitioner.
yes.
Practitioner of the High Court. This is the difficult thing.
Okay. Yes. Yes.
My lord, I retired from the cooperative bank. I retired from cooperative bank on 30th of April 2021. This is very important.
30th April 2021. Retired. From which post?
Of the Vidyasagar Central Cooperative Bank.
Achha, you from which post you retired?
I was the which
Okay.
post? I was the
Clerical gate. Okay. Yes.
I'm showing it.
Thereafter, what happened?
Lord, I made representation to pay my retirement benefits. Retirement benefits is under the law. I am entitled under the law. That is the rules. And under the rules, I am entitled to gratuity. That is the cooperative law. Then I came before this honorable court. A point was taken that this writ petition is not maintainable. Now that particular objection has been overruled by Justice Bhattacharya. Just kindly see the order. Please. My lord, this is. My lord, he is not a lawyer. He is not a lawyer of the High Court. That is the difficulty. He is practicing in the registrar office. He cannot understand the decorum of the High Court. Very difficult. The very rough lawyer. My lord, kindly see the orders. An objection as to the maintainability is taken by the learned counsel appearing for the respondent number 4 and 5. Primarily on two grounds. First, the component of penal action in respect of disciplinary proceeding. It is submitted is amenable to appeal under Rule 106 of the West Bengal Cooperative Societies Rules 2011. That apart, That apart, it is contended that section 102(1)(c) of the Cooperative Societies Act 2006 mandates that disputes of the present nature are to be delegated to the registered cooperative society. It is further submitted that response number 4 and 5 are not at all agreeable to payment of amount of gratuity sought by the petitioner or interest at the rate of 18%, which has been claimed by the rate petitioner as well. Learned counsel for the respondent number 4 and 5 as such seeks to use an affidavit in opposition detailing their side of the facts of the case. Learned for the petitioner in reply contends that Section 102(1)(c) is not attracted to the present case in view of subsection 1 of the said section.
Okay, the court recorded the submission made by the respective parties, and then court said that be that as it may, since the respondent seeks to use an affidavit opposition to bring on record their version of the relevant fact of this case, the respondent are directed to file their affidavit within such a period, and in the meantime, respondent bank shall disburse the admitted retired benefit of the petitioner within the time specified.
Okay. Now,
Without prejudice to the rights and contention of the party.
And now,
So the issue has not been decided.
in
Later,
term-
it has been kept open to be decided. Yes,
without prejudice to rights and contention.
contention.
Kindly see,
This submission was submitted that it was contended that the petitioner did not challenge any penal action.
I am not
Record. So, rule 106 is not
This is,
applicable.
This is not the issue now. After the order passed by this Honorable High Court, this order was passed by them, granting retail benefits, accepting full amount of
Admitted
gratuity, full
retirement
amount of
benefit.
gratuity. So they complied with the order. Only accepting full amount of retail gratuity. Now I have come now before your lordship with regard to full amount of gratuity under the Payment of Gratuity Act. Court passed, they accepted this particular payment, admitted my claim. With regard to other, I have got no.
So all the retirement benefit would be disbursed through SB account such and such. So you actually have got the relief.
Kindly see clause 1 first. Final gratuity for rupees
10 lakh only
10
to be
lakh.
paid by LIC.
Yes.
Kolkata
Now, under the law,
under group gratuity scheme of LIC.
with regard to other, I have got no grievance. With regard to gratuity, I have the grievance because they are saying that I am entitled to gratuity. They paid the gratuity, but they have paid less because page 39, kindly come, page 39. Page 39, Government of India Circular, and kindly see section 4 of the Payment of Gratuity Act. Section 4 of Payment of Gratuity Act. Kindly see now section 4, subsection 3. I'm giving the kindly. Section 4, subsection 3, and the government notification.
Yes.
The gratuity will be paid as at the amount as and when prescribed by the Government of India, central government. Lordship, kindly section 4, subsection 3.
The amount of gratuity payable to the employee shall not exceed such amount as may be notified by the central government from time to time.
Later part, I have given the mark. Kindly see the government circular of 1918. See the circular now at page 39. And it has been annexed to rupees 20 lakhs from 2018.
Shall not exceed 20 lakh.
Yes. Shall not exceed 20 lakhs. Now, I'm entitled to 20 lakhs. Because of my service career and length of service, I'm entitled to 20 lakhs. 1 point. Second point, having retired in 2001, payment to 2021, payment was not made immediately.
Delayed payment.
Not immediately.
When it was paid?
Payment by letter dated 6 May 2022. It was directed to be paid. With regard to date, I am taking the date 6 May 2022 as the final one. I am not disputing with the same. When I received, I cannot say. Kindly see. He is the general manager. Kindly consider
from 1st April 2021 to 6 May 2022, you will get interest.
Kindly see, my lord. One thing, my lord, who has signed the order? Kindly see. General manager. Kindly see. That order. General manager passed the order.
This order?
This order has been passed by the general manager.
Yes, yes.
He, since he is the head of the administration under the law, he passed the order, he disbursed the money. There is no question of any deliberation with the managing committee or not. He is there. For what? Now this learned advocate is appearing for him.
No, I am not. I am for general manager is number 6.
Whoever appears, my lord. My lord, now you also can direct upon the general manager, who is the respondent number. I am giving the respondent number.
So now you are appearing for whom?
4 and 5.
Bank. My lord, I am 4 and 5. Respondent number 6, general manager.
4 and 5 means you are appearing for Vidyasagar Central Cooperative Bank Limited. Now the 6th is general manager of your bank.
But I am not another advocate is there. But I know the fact I will make answer of
You are for the general. How? 2 advocates for general manager, 1 advocate for cooperative society, for another advocate. How?
This is the difficulty now. Some lawyers are interested to hobnob with the general manager. He is the deputy registrar.
Now, how this sort of representation from cooperative society? General manager is one of the functionaries of the cooperative society.
No, appointed by the government. Appointed by the government. No, my lord, I am making a prayer.
So for board of director, it is run by a board of director. There is a general body of the also. With the appellate authority in such discipline matter, appellate authority is so general manager.
No, appellate authority is general body.
General body, yes.
Not the board of directors.
General body, yes.
BCID board, thereafter chairman, thereafter general. This is the proposition.
Chairman is the above the board.
No, chairman then general board. Yes, chairman above the board because of the Cooperative Society Act provides that the general chairman is the overall power subject to decision of the.
I don't know. I don't know which law in democratic society place a person over a body. I cannot
I will make five. I make 5 minutes submission. No.
Okay, although this representation is appearing to be odd and not accepted, if different versions come from, then the court will be bound to reject the representation of general manager by any particular any other advocate.
Actually, general manager position of general manager is the government officer. He is appointed under section 53 to act on behalf of the as a secretary of the bank. In the bank, actually there is no secretary, and in place of secretary, for bank general manager or chief officer act on behalf of the bank. The duties as laid down in Rule 57 of the Cooperative Society. But question is this: there is general. Therefore, board is independent. Board is important. Fact is this: although he has prospected, he has met the society and the board, and that's why I was empowered by the special officer and the then manager empowered by. But actually, there was no board when the matter was filed. Now, till now, there is no board. And that's why I said about the policy decision, how the policy decision can be taken by the board, special officer or by the general manager. They cannot take the policy decision. There are several judgments, my lord, in the regard to this special power.
Which policy decision required to be taken to pay the gratuity amount of one retired employee?
Policy decision of excess payment. I'll tell you. Let him give that.
Policy decision of excess payment.
Yeah, he has claimed that.
Or for making payment of a retirement benefit of his employee, a policy decision is to be taken.
Excess payment.
You are unable to handle the board. Let one administrator be appointed.
No.
You are unable and incompetent to to pay the retirement benefit of an employee whose service you have exploited for numbers of years. Policy decision is to be taken.
No, that is
so that cooperative society is unable to function.
I am sorry.
Incompetent to function.
Sorry to say, only the point of the
okay, in which bank you deal with account you deal with? In which bank you deal with to handle your account or keep deposit your money? Yeah, that money will be a special officer shall be appointed by the court to handle that amount.
I am sorry.
Yes, you make the submission. No. You sit. I shall hear the submission of both of you. If it comes, then not according to the record and according to the rule, then I shall reject the representation of any one of you. Yes, you go on.
My lord, my submission before your lordship. Your lordship, can you see the last part of the order?
Yes.
It is to be noted.
Noted that a sum of rupees only
only is receivable from you. So they have not said any other money is due to be paid by me. Somebody is claiming before your lordship that 30 lakh, 20 lakh, 50 lakh, 1 lakh will be, they say, is receivable from you. And the punishment, with regard to punishment, they said, you pay 3 lakhs, this is the punishment given to you. Can't you see the order? Disciplinary proceeding. He is shouting about the disciplinary proceeding. Can't you see?
Against retired employee?
Yes, can't you?
They are going to initiate a
proceeding was taken. Thereafter, they want to take the disciplinary proceeding again. Then I came before this honorable court. Honorable court said, page 89. Said, no, you can't.
Master-servant relationship is about.
Kindly see.
No, sir. My lord, this type of action.
Kindly see the order. This is. Kindly see page 89. The writ petitioner is aggrieved by the fact that a show cause notice has been issued to him in respect of a certain irregularities committed by him while he is in service. Charge sheet has been issued after superannuation. Since the rules in question do not permit proceedings to be continued post superannuation, the proceedings are vitiated. society shall, however, forthwith institute civil proceeding for recovery of loss suffered by the society before the registrar for appointment of an arbitrator.
Okay, so now the issue to be resolved is that whether you will
Now,
get 10 lakhs more or not.
They have foregone everything. They have foregone everything. Now
They have not instituted any civil
now they have
proceedings
passed.
and criminal proceedings.
They have passed that you are entitled to retirement benefits.
Such and
but
such.
I am only disputing with regard to gratuity amount, nothing else.
Gratuity amount and interest.
That this is the one. Second point. Since the belated payment has been made, I am entitled to interest. These are my submissions.
Yes. So you just show me that how you can claim 20 lakhs as gratuity.
Huh? Oh, see, page 39. Page 39.
Of the writ petition.
Page 39 of the petition government circular. Page 39. Kindly see page 40. Page 40. SO, statutory order. This is statutory order.
Yes, it is shall not. It shall not exist. Okay, yeah, the matter will be continued.
Shall not exist. I am entitled to 20 lakhs. There is no dispute.
Come at 2. I have a different bench.
No, he is only registered.
Okay,
He has no case in Calcutta High Court.
Today I have another bench. I have another bench at 1 p.m. I am to go. So come tomorrow.
Thursday.
Thursday. Okay, Thursday. Act 2. Huh? लिखी थी ना अच्छा Yes. I had to see it again with Justice Chakraborty. Yes, you have possible matter.
Hi, my lord. I appear on behalf of the petition.
Yes.
My lord, the petitioner before my lord, he was appointed as constable in the Central Industrial Security Force, that is CISF, on 10 September 1991. While he was posted at CISF unit at Mejia Thermal Power Station, he was served with a major penalty charge sheet on the allegation that he secured government job on the basis of a fake ST certificate. And my lord, he was appointed in the CISF service, my lord, on the basis of a against ST quota reservation. Now, my lord, the allegation is that I secured government service on the basis of a fake ST certificate. My lord, very kindly turn to page 96. It is the
Charge, nahi. 96, yes.
Page 96, it is the caste certificate duly issued by the SDO Ranaghat Nadia. Now, my lord, the disciplinary proceeding was initiated. I was removed from service. Appeal and revision application failed. Thereafter, I am before my lord. Now, my lord, I am placing paragraph 12 at page 10. My lord, fact remains, while I was residing with in my sister's house in Ranaghat, the said caste certificate was issued by the SDO Ranaghat. Now, my lord, very next page I am placing paragraph 13. My lord, they raised objection and they have questioned the veracity of the caste certificate. Their action kindly appreciate. Respondents have questioned the veracity of the caste certificate that is such as issued by the subdivisional officer Ranaghat Nadia. But the said caste certificate was forwarded by the respondents to the district magistrate, North Chobis Parganas, Barasat. This is their conduct. This is their act. My lord, the certificate was issued by the SDO Ranaghat. For verification, that has been sent to North Chobis Parganas, Barasat. My lord, I do not know what was the reason. Now, I am placing the fact, my lord. The
district magistrate called for report from the SDO concerned.
SDO.
So whether it was issued by you or not.
Yes, but my lord, very kindly turn to last page of this writ petition 101.
Yes.
They have sent to the
district magistrate ADM, Northwest of Barasat. What is the report of his? In reference to his letter dated such and such cited above, it is to state that no caste certificate, such certificate SC/ST at all were at all issued from that end in favor of the above mentioned individuals as per reports received from Sub-Divisional Ranaghat, Nodia. Two persons subject. One Ashish Kumar Das, son of such and such, and two Torun Chandra Das. I am Torun Chandra Mondol, but they have certified that Torun Chandra Das. And on that basis, they acted. They
Okay, their reference letter, letter is 99/2010, E-3099, such and such 2000. Yeah. By that letter, they communicated to DM concerned. They call for a report or information as to whether such certificate was issued or not.
Yes.
The SDO is the certificate issuing authority.
Yes.
Most probably Section 5 of the West Bengal Scheduled Caste Scheduled Type Identification Act, 1994. Now it is the SDO who will declare that whether he issued a certificate at any point of time or not.
Yes, but kindly appreciate who? Torun Chandra Das, another person, not me. I am Torun Chandra Mondol. Petitioner before my Lord Torun Chandra Mondol. And it was pointed out, they ignored. They ignored, and on that basis, inquiry was, my service was terminated. Torun Chandra Das, the certificate issued against for Torun Chandra Das was not issued by this office. It has been stated. But I am not Torun Chandra Das, I am Torun Chandra Mondol. Now, my lord, I am placing the observation of the department, my lord. Kindly have a turn to page 39.
Now, where that communication to the DM concerned? Communication.
My lord, another thing, my lord, another thing, the vital point, my lord, complaint. There must have been certain complaint in this regard. My lord, no complainant was ever examined, no complainant was ever called for to appear before the inquiry authority. Only the SDO Ranaghat, then SDO Ranaghat was requested by the inquiring authority to appear, but he did not appear. His one office bearer was sent to depose on his behalf. It is also impermissible. My lord, he was the complainant. No complainant was examined. Your lordship knows very well, my lord. Unless the complainant is examined, it cannot be said that that complaint has been proved conclusively. Now, my lord, I am placing.
Now, where is that communication from the assistant commandant or commandant to DM? That you stated that it was communicated to the DM?
Yes, my lord, I am placing. My lord, that is reflected in their report. My lord, I am placing reading page 39. Kindly have a look.
Page 39.
Page 39. Brief of presenting officer against CISF such and such. In compliance with such and such, Inspector such and such who was appointed as inquiry officer, and Mr. Ghosh was detailed as presenting officer to conduct departmental inquiry under rule such and such. Thereafter, my lord, middle portion I am placing during the course of inquiry, my lord, 8 or 10 lines from top. During the course of inquiry, the charged official Constable Torun Chandra Mandal was given sufficient opportunity to cross-examine all the prosecutor witnesses. On 4/4/2011, one letter has been received by the inquiry officer from Constable Torun Chandra Mandal that he wants to cross-examine the SDO Ranaghat, and accordingly, inquiry notice was served to the SDO Ranaghat, fixing a date of inquiry on 8/4/11. Time 10 hours. Accordingly, at CISF unit Mejia, the inquiry notice was received at SDO Ranaghat on 5/4/11, but SDO Ranaghat did not turn up on 8/4/11. Thereafter, one letter was received on 8/4/11 by the inquiry officer from the charged official that he wants to proceed to SDO Ranaghat to give him an opportunity regarding inquiry. Accordingly, an inquiry notice was served fixing a date of inquiry on 12/4/11 at the office of SDO Ranaghat. On 12/4/11, the statement was recorded from Sri Madhav Chattopadhyay and OC Ranaghat as a court witness on behalf of SDO Ranaghat. On behalf of SDO Ranaghat, the SDO Ranaghat was never examined. On his behalf, some other person was examined. On his behalf.
Who became witness? That is the principle of witness. 136, 139, who became witness? The person who is acquainted with the fact and circumstances. The person who is asked to supply some information or produce some document, he is not the witness.
He is the SDO.
He is not the witness. Suppose there was a tussle or clash in a particular place. The doctor has not seen, or the hospital staffs have not seen the incident. He will not be witness. He has not acquainted with the fact and circumstances. If any information is sought for by the court, whether this man was under treatment of your establishment, the hospital or not, you produce the document. Anyone from the hospital can produce that document. Anyone.
Yes.
You will say that from record I have found that on such and such that one person admitted in such and such ward, he was admitted such and such ward, he was discharged on such and such date. His duty is completed.
But
he is not witness. He has not seen the evidence. He has no direct knowledge about the incident.
In my humble submission, the caste certificate was issued in 86, and
he has stated that no such certificate has been issued from this establishment.
From the against whom, my lord, I am asking myself, against whom? Against Torun Chandra Das.
You come to page 101.
Yes.
101, and before that you come to your certificate page. Your certificate, kindly give me the page number. Certificate. I just
certificate is appearing at 100.
Certificate?
Page 96.
Page 96.
96. This is the certificate.
Yes, page 96. At the top, there is a number.
Yes.
15060-S/T dated 29th June 1996. Now come to page 101.
Yes.
Now you come to subject. Reply of verification of the caste certificate bearing number such and such. It is act number 1. And 2. 1560-ST dated such and such.
29/6/86.
Yes.
But
verification, it is not a typographical mistake one. Thus,
there was no coding and nothing.
Question or information was asked from the establishment of the DM and including the SDO whether the certificate bearing number 1560 such and such S/T dated such and such was issued from your end or not. Apply came in negative.
it has been stated that it was not issued
But-
I repeat, against Torun Chandra Das, not against Torun Chandra Mondol.
Okay, okay.
And my lord,
It
my
is
lord,
yours.
it fell from my lord observation that the typographical mistake. My lord, typographical mistake.
Prima facie view.
Prima facie.
Now,
Now, my lord, very kindly turn to pre-page, page 97.
Page 97.
This is another certificate has been issued by the SDO North Chobis Pargana. Subsequently, I changed my residence. I became a resident of North Chobis Pargana, Barasat. This certificate was issued. It has never been declared to be a fake.
However, this certificate has not been used by you.
No. Used by, my lord. After obtaining this certificate, I supplied.
Now, you offer your candidature claiming himself to be a candidate belonging to ST community.
Yes.
Based on your certificate, page 96. File number 1560. Information.
My lord's observation is number is same.
Yes.
Name maybe
Name in
wrongly
the
typed. Name maybe wrongly typed. It is my lord's observation.
In the subject of the of a communication of the additional district magistrate. But 1560 question was 1560.
My lord's observation.
My lord, it is appearing from the record.
Now, my lord. Now, my lord.
Yes.
Kindly have a turn to page 41, my lord.
41.
Summary of the statements of PWs.
PW2.
Two statement of CISF such and such. He stated the Constable Torun Chandra Mondal, son of such and such, major resident of North Chobis Pargana, was applied for appointment for the post of Constable GD in CISF in the quota fixed for ST candidates, duly producing ST certificate bearing 1560 ST, dated 29/6/86. The above said caste certificate, which is appearing at page 96. Caste certificate was forwarded to the district magistrate, North Chobis Pargana, West Bengal. My lord, kindly take note of it, my lord. The caste certificate was, I repeat, my lord, the caste certificate was issued by the SDO, Ranaghat, Nodia, and it is clear from the observation that the above said caste certificate was forwarded to the DM 24 Parganas, West Bengal, 24 Parganas. He was not the issuing authority. Issuing authority was Ranaghat, Nodia, and it has been sent to North Chobis Pargana for verification. For what they know.
এইখানটা দেখে দিলে একদম একটা অ্যাপিয়ার হবে। Yes.
Said caste certificate forwarded to North Chobis Pargana, my lord, for necessary verification. As per verification report received by DM office 24 Basak letter number sir duly endorsed enclosing SDO Ranaghat Nodia, which specifically states that the said caste certificate has not been issued by SDO Ranaghat Nodia. To confirm the matter, Inspector such and such of this unit was detailed to visit SDO Ranaghat. The SDO Ranaghat has confirmed letter dated 31/12/10 was issued from this office. Constable Torun Chandra Mondal of CSA in order to gain appointment of, this is the observation. Now, my lord, very next page 42, 4. Statement of CISF personnel. He stated that Torun Chandra Mondal, son of such and such, applied for appointment in quota fix duly producing ST certificate bearing his above caste certificate was forwarded to the DM North 24 Pargana, West Bengal, for necessary verification. My lord, it was never sent to the issuing authorities office. It was never sent to the office wherefrom it was issued. It was sent for verification to some other office who has had no knowledge about this. They did not issue. The issuing authority is Ranaghat, Nadia district, but they have asked for verification from the North 24 Pargana authority. And my lord, in nowhere during the proceeding, it was claimed by the respondents, any of the respondents or PWs or anybody, that caste certificate was prepared by me, or it is a fake, it is not a genuine. No, nor it has been prepared by me. No, no such allegation from any corner arises. The now, my lord, in my humble submission, my lord, there was some allegation that I secured job on the basis of fake certificate. So, my lord, there must have been a complainant, must be a complainant. No complainant has ever been examined. Your lordship knows very well this is the fatal principle of law. My lord, unless a complainant is examined and unless that complainant is to be cross-examined by the delinquent, My lord, it cannot be said that the complaint has been proved. It is a settled principle of law, your lordship knows very well, my lord. When it is seen that no complaint has been examined, then everything goes. You are a man of which district? Most probably you are a man of North District, District 24 Pargana. No. Yes. My lord, yes, I have stated. You are a man of District North 24 Pargana. And hence DM was asked to verify. When this certificate was issued, I have categorically stated in my petition in paragraph. When you were appointed? My lord. You are appointed on? Yes, my lord. It is appearing at page 12. Page 10, paragraph 12. The petitioner states and contains that at the time of entry into service, the petitioner was residing with his sister and brother-in-law at Nodia. 1991. And the charge sheet was issued 2011. Subsequently, I changed my residence to North Chobbish Pargana. On verifying and on thorough scrutiny, the competent authority being Subdivisional Officer Ranaghat Nodia issued the necessary caste certificate on 29/6/86 in favor of the petitioner, declaring the petitioner to be a member of scheduled tribe community Bhumij. The authenticity which was not questioned, rather could not be questioned by the respondent authority at any time. And as such, the petitioner was given appointed in the service of the force. My lord, the administration of the respondent authorities, they, after thorough scrutiny and inquiry, they have recruited me in the force. Now, my lord, subsequently on the basis of a floating complaint, they initiated proceeding on the basis of perverse observation. They have terminated my service. Okay. Now, violation of principle of natural justice, your lordship knows very well. I did not. No. Even then, my lord, this is one and this is another, my lord. Dismissal order, when departmental inquiry is defective, everything goes. My lord, the complainant must have been given the opportunity. The complainant must be examined, and the delinquent must be given an opportunity to cross-examine the complainant. Here, there was no complainant, nothing of that sort. Simply from air, I do not know the source of such information, they did not disclose. However, my lord, they received one complaint. They should have disclosed the source of complaint so that I could pray before them to cross-examine that complainant. No complainant, nobody. And my lord, on the basis of the said certificate, while Nodia, while I was a resident of Nodia district, my lord, they questioned. And what they did, they have sent that certificate to another district for verification. It is unheard of. Your Lordship kindly appreciate. However, my lord, for further proceeding, my lord, I applied before the North Chubis authorities, wherein subsequently I shifted my residence. On my application, on my prayer, ST certificate was granted, issued in my favor. It is appearing at page 97. My lord, had it been a case of the respondents that I was not at all a community of member of scheduled tribe community, that is another thing. But my lord, first of all, it was issued by the competent authority of Nadia district. Secondly, it was, since I changed my residence to North Chubis Pargana, secondly, further caste certificate was issued by that office, by the competent authority. There was no illegality, no infirmity. Even then, my lord, on the basis of hearsay, without examining, without giving any opportunity of cross-examine, without examining any complainant, they have removed me from service. My lord, it cannot be. Now, my lord, yes. Now, my lord, I may permit to hand over a copy of judgment of this honorable court, my lord, on this point. It could be. তোমার লাগবে নাকি? আসবে? তোমার তো আসবে। তোমার ধরো। My lord, paragraph, my lord, page 33, have a turn to. Page 33, submission of the learned advocates. I am placing, my lord, 3. Mr. Devabrata Sahara, learned appearing for the petitioner, submit that decision of the disciplinary authority subsequently affirmed by the appellate authority are wholly erroneous, illegal, suffers from lack of procedural mistakes. My lord, very next page, the necessary judgments have been cited. Mr. Sahara also contended that no medical board was constituted to examine the petitioner to ascertain. My lord, there was another complaint. On that score, my lord, there was no complaint. No medical board was constituted. The 3 judgments have been cited here, my lord, wherein the issue of examining the complainant and a chance to the delinquent to cross-examine the complainant, since we are not adhered, the entire disciplinary proceeding goes. This is the observation in this judgment of this honorable court. And lastly, kindly have a turn to page 45. Lastly, 26. The disciplinary proceeding, including the order of punishment, shall mark the appellate order stands set aside. Everything goes. Thereafter, my lord, what is the observation? The petitioner shall be reinstated in service within 4 weeks from the date of communication of this order. Petitioner shall be entitled to 50% of his back wages during the period spent under dismissal. Such amount is directed to be paid based on the conclusion reached by me, and had he not been fastened with the order of dismissal, he would have served the authority and earned his salary. Now I am 52 years old. It is also worthwhile to note that no evidence had been produced on behalf of the authority to establish that the petitioner was in gainful employment during the period of dismissal. So, my lord, in my humble submission, my lord, everything must go. My lord, my age is 52. My lord, I should be reinstated with service continuity, and on the basis of this judgment, at least 50% salary. And in addition to that, with interest. This is my. Yes.
The first charge was relating to the forged certificate, Lordship. And Lordship sees that the entire inquiry proceedings, Lordship, has been held in presence of my learned friend's client. He's been given an opportunity to cross-examine, and no witness has been cross-examined. Lordship, I'll just take your Lordship through page the brief of the presenting officer, Lordship, brief summary. Last line is, during inquiry, Constable Tarun Chandra Mondal was given the opportunity to cross-examine PW1, but he did not ask any question. PW1, PW2, PW3, all PW4, Lordship sees each and every PW. Then we come to CW, Lordship, if your Lordships remember, that he had wanted to examine, we had taken it was that part of the examination was well held in Ranaghat, and the documents were produced, Lordship. There too, no questions were. So now it cannot be said that I have not been given an opportunity. As my learned friend is pointing out, he has been given ample opportunity to prove his case, Lordship. The case is that Ranaghat did not issue that particular certificate, Lordship. Whether he got one subsequently is not. But at the time of public employment, the document relied upon by him for getting the job in a particular quota was not issued by the proper authority. So it's not a question of Dash or Mondal. The document itself was not issued. Had that been the case, then they would have surely said not issued in favor of Mondal, but in favor of that. But this document was not issued. Lordship, my learned friend has dealt with why did we go to the North 24 Parganas deal. Lordship, that was, as we see the address given in the cause title also, was not 24 Parganas. His cases, while I was residing with my sister and brother-in-law, I had applied, according to him. So That was at one point of time, maybe, but then his cases, he's a resident of North 24 Parganas. Whatever was appearing from the records, his domicile was North 24 Parganas, probably at that point of time. Whatever it is, it was sent. Again, they sent it to the due person. It's not that North 24 Parganas said anything. Again, a verification exercise was conducted by North 24 Parganas and the authority who had purportedly issued that certificate was also questioned, and they confirmed that 1560 certificate number was not issued. So the issue is, Lordship, I'll just let your Lordships will kindly come to the affidavit in opposition. Lordship,
Isn't the affidavit in opposition?
Lordship, it was an opposition filed on behalf of respondent numbers 1, 2, 3, and 4.
Everything reply page.
Lordship. It was filed by Manoj Malhotra.
Huh? The affidavit in opposition that they can reply at it.
Not there.
They want
He'll have to reaffirm and type for product. You don't know type.
Have you got the copy, spare copy?
It's marked, everything is reply, opposition page. Lordship.
Some markings are there.
It's full of markings.
You get a copy.
Then in that, in fact, Lordship, I should I should make a fresh copy, reaffirm it, or whatever it is. I mean, because a Xerox copy, Lordship, my learned friend has been very curious about this matter. It's been marked. So, Lordship, this I don't think I should.
So, in course of day, will you give it? So, court will pass an order that the copy shall be treated as an original, original affidavit in opposition.
পেন্সিলে লিখেছি উনি কলমে লিখেছেন চলবে না
Have you got the copy?
His is more marked, Lordship. Worse than ours, at least we can erase it. It's pencil marked, so we can rub it off.
Okay.
And
so in course of this day,
yes, Lordship,
though Mrs. Alam Lanet advocate submitted that the affidavit in opposition was filed in court, but on close scrutiny of the record, it is appearing that the copy of such affidavit in opposition is not with the record. So to avoid any confusion, a copy of the affidavit in opposition, avoid, on being asked, Mrs. Alam has submitted a copy of the affidavit in opposition. ঠিক আছে? Mr. Chakraborty has confirmed that it is the copy of original affidavit in opposition, and hence the same is accepted to be the authenticated copy of the affidavit in opposition used on behalf of the respondent. Okay, you check if you want to check what they will submit.
What they have supplied, it is with
him.
Yes.
And Lordship, Lordship, in that opposition, Lordship, my learned friend is there, that dispute relating to the name Mondol or Dash, that also has been kept. I'll just place the document. My learned friend had placed the document where 2 certificates were verified. One certificate in the name of Ashish Dash, and the other certificate, which is the 1560, that was in favor of Torun Chandra Das. Lordship, my learned friend had made much reliance. Lordship, I have annexed a document dated 20th of October 2010 that has been issued by the subdivisional officer Ranaghat Nodia to the additional district magistrate at Barashat, saying that this is to inform him that no caste certificate was issued under number 1560 ST dated 29,686 to Torun Chandra Mondol, son of Nokul Chandra Mondol of Dupli from this office, as it revealed from the office rep. So that mystery is also been cleared. Lordship will then the next page is addressed, again issued by the subdivisional officer, addressed to the CISM. With reference to your application dated 31st of December 2010, this is to mention that the report as sent by this office memo, number so and so, addressed to the additional district magistrate North 24 Parganas Barashwat, was issued from this office. So, Lordship, there is no confusion relating to that certificate. All these documents have been handed over. During the inquiry, Lordship, both the charges, they've got ample opportunity to defend himself, and each and every witness have shown your Lordship, he was asked to cross-examination. So whatever evidence has been collected is unchallenged. So under these circumstances, even the clerical error has also been cleared on the basis of records on the witness. Therefore, Lordship, the the fake certificate was used at the time of entry into employment. Lordship. There is, the preponderance of probabilities, all the probabilities point to that. I shall hand over that.
Anything in reply? Yes, my lord. My lord, just now, my learned friend submitted that on the basis of the certificate produced by me, I was given appointment. My lord, it was their bounden duty to make an inquiry whether this is at that time, not after 10 years or 15 years. Now, my lord, when I asked them to call for the SDO Ranagar, they issued notice to the SDO Ranagar. He did not turn up. One of his office official came and deposed such and such. Now, my lord, to that, my lord, my answer is representative cannot be a spokesman to confirm the action of the SDO. Representative, I have taken this point in my agreement reply. Representative cannot depose on behalf of the SDO. While SDO says that no such certificate was issued from this office by him, that cannot be verified by his representative. That cannot be verified. He is saying that it was not issued. His office bearer, some other office personnel cannot say that no, it is. Now, my lord, again the SDO should have been allowed to cross-examine. It is the duty of the authorities to bring on record the deposition of the SDO. Nothing. So, no question for the petitioner to ask the authority to bring the SDO for examination. The person on whose statement such inquiry was conducted, if or at all, must have been produced. What I am on? There was a complaint, I produced fake certificate. Where from that complaint came, that source should be taken.
You have stated so.
Yes, my lord. My lord, nothing. And my lord, this certificate appearing at last page of the writ petition, that Torun Chandra Das. My lord, in my humble submission, if I am not wrong, my lord, in the opposition, never any corrigendum has been taken by the respondents that yes, typing mistake was there, it should be this. No, nothing. So, my lord, in my humble submission, my lord, the certificate which was issued
To who prevented you from examining the witnesses?
my lord, there was the
In
SDO
criminal
was
court,
not there. The
there
SDO,
and there you
my lord, the
would have go to jail.
SDO was called for deposing. He did not turn up. He was the complainant.
Look,
So, my lord, the
yeah,
authority, his
no one cannot be asked to prove negative fact. Negative fact can be nullified only by proving a positive fact. If any version come from the SD office that no such certificate has been given, now to disprove the same or to rebut the same, you have to prove evidence. This is the certificate you produced. Memo
no,
number.
no, my lord, the SDO has said
SDO,
that
I have stated.
SDO
SDO,
has stated that no certificate.
you
SDO is
subsequent.
not forthcoming. He did not come forward.
You could have asked any competent person. Or everywhere SDO will have to go, leaving his wife work. Every day he is issuing certificate.
Chipra, I just missed out on my learned friend's submission on the case law, Lordship, which he has relied upon. Lordship, that my humble submission is something totally different from this case. It was a question where there was no medical report, allegation of being drunk, and it had really shocked the conscience of the court. The punishment was disproportionate. That was a case of drunken behavior, whatever it is, no medical report, and on the basis of that, the court had.
This is civil on fact.
So it is totally on a different.
Provision of law is said. Whether examination of
Okay, it is his submission.
That is my submission. You might not agree, Lordship, in paragraph, and therefore there's no question of return of back wages or anything, Lordship. That is not, there is no, and I just.
No, I did not say that facts. Proposition
The
law.
proposition of law, Lordship, is
Proposition law.
based on the fact, Lordship, it is not. Therefore, and Lordship, I'm just relying on this decision of by the Honorable Apex Court in the case of Subratanath, Lordship. That how, I mean, we cannot sit over an appeal. We have to appreciate the evidence, Lordship. This is
22.
Lordship, I am relying on paragraphs
15, 22, 23.
15, 22,
23.
It's on the celebrated case of B.C. Chaturvedi, that how the court should look into, and in my humble submission, the procedural, there is
no procedural defect. Settled principle of law.
It's a settled.
From Chaturvedi to
Yes,
Gunasaran, Gunasekaran, all settled. Acha, hearing concluded.
But that we shall give the
judgment is up. I
grateful.
The learned advocate for the authorities, he just fell outside the court, he's bruised his leg.
Oh,
So I'm praying for this week, not this week.
No, not this week, not this week. Okay. So no other matter today?
35 is there.
Oh, 35, yes. Oh, 35, 36, 37. Same pair, so who has fell down?
My lord, in respect of item number 36, I'm praying for 1 week time to file affidavit. Report has been,
36.
yes, my lord.
Acha.
There is a direction for filing affidavit. Matter is relating.
No affidavit in opposition has been filed.
No.
There is a direction for filing affidavit, my lord.
It's on a short point of law, no
Yeah.
affidavit. Of course,
No.
if they want to
Yes.
submit, I cannot stand.
Here I
in the
will
way.
submit a affidavit, my lord. There is a direction for filing affidavit.
36 din.
Yes, my lord.
What about 35? 35 not this week.
35, nobody is for the state.
So,
I'm ready.
so not today.
Not today.
Okay, 35 not today. 36
And for one
direction
week.
for Acha. When direction was given to file affidavit?
Yes, ma'am.
13 August 2024.
Yes, ma'am. Report has been received. I have talked to the DI, my lord, and saying for 1 week.
Acha. You are Mr. Mitro?
Yes, my lord.
Acha. Mr. Mitro, Lalit advocate.
Oh, 37.
37.
Again, my lord.
Huh?
I'm ready to do the matter if she.
Are you ready?
And the matter, my lord, I'll tell you, my lord, all these matters.
Code number 15 lordship, not today lordship.
So do it tomorrow.
Yes.
Not today lordship.
Do it tomorrow.
The matter is very small, higher scale of paint.
Okay, okay.
And the larger paint, it is well settled.
Oh, okay. Come tomorrow.